The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in case 19-8709, Greer versus United States. Ms. Guayardo.
Mr. Chief Justice, and may it please the Court. The question at issue concerns the method an appellate court applies in conducting plain error review of a defendant's trial, and in particular, what body of evidence an appellate court may rely on to affirm a defendant's conviction at that trial. In this case, the 11th Circuit affirmed Mr. Greer's conviction by relying on information that had never been introduced at his trial. There are three fundamental problems with this approach. First, at prong 3 of plain error review, the inquiry is whether the errors affected the outcome of the trial, meaning that verdict of guilt. Looking at information that was never before the fact finder at trial is not relevant to that inquiry. Second, at prong 4 of plain error review, it is fundamentally unfair to affirm a defendant's conviction based on information never introduced against him at trial. At a trial, a defendant is on notice that anything being introduced may be used by the fact finder to determine his guilt. But outside the record of the trial, information may go untested and not be reliable for determining guilt. That is particularly the case here, where because of the uniform circuit precedent before Rahave, at no proceeding in the district court had the parties addressed or the judge found the mens rea required by this court in Rahave. The record was simply not constructed to address this element of the offense. And third, there are practical problems to such an approach. Once an appellate court relies on information not used to trial to affirm a defendant's conviction, embroiling the appellate court's investigation of whether that information is reliable enough to affirm a defendant's. Thank you.
Thank you, counsel. Let's suppose you have a defendant who is convicted under 922G prior to Rahave, and on appeal she argues that if she had known she had to establish, or the prosecution had to establish a felon, that she knew that she was a felon, that she would have introduced mental health evidence to show that she was incapable of that knowledge. In that case, could the reviewing court look at that evidence of mental illness, which was not presented to the jury, not presented on trial, on plain error review, or does your rule bar only the prosecution?
Your Honor, our rule applies, it depends on what the nature of the error is. In that instance, the defendant would be, the claimed error would be the exclusion of evidence. And that, so therefore the appellate court could look at that in terms of reviewing the nature of that error. But if the claim is what it is here, such as an insufficiency of the evidence claim, then that evidence or that information the defendant is offering would not be considered. So our rule on an insufficiency claim is that it's still limited to what was introduced at the trial.
Well, that's the basis of my question. I'm not sure why you limit your analysis in that way, and the fact that there are many, many situations where we obviously do allow consideration of evidence outside the record in assessing a claim of trial error. I don't know why this would be treated differently.
It will depend, Your Honor, on what the claimed error is. And with an insufficiency claim, the question is, and this goes back to the court's earliest cases, such as in Clyott and Weiberg, what was the information or the evidence introduced before the fact finder? Was that evidence sufficient? And that remains the inquiry even on plain error review, Your Honor. Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, would you be kind enough to tell me what language from or text from 52B that you're relying on?
Your Honor, with respect to the text in 52B, it's the denial, or the inquiry is the substantial rights inquiry. And then with respect to prong 4, this court has interpreted the may to require an analysis of whether the error has seriously undermined the fairness, integrity, and reputation of the proceedings.
Well, isn't that quite a burden to put on that language that is doesn't seem to have sort of internally or intrinsically the limitation you're placing on it?
Your Honor, our request is that what the court looks at, or our reading of Rule 52, which is informed by this court's precedents, is whether the errors, which is still what the court is looking at. When a court is reviewing a case, it's reviewing the errors that already occurred. And at a trial, when they claimed error is the sufficiency of the evidence, that the process itself designed to address whether the outcome of the proceedings, which is a guilty verdict, the outcome of that cannot be assessed by a process, an appellate process that is itself not fair, or further the other considerations in prong 4.
So if you win here, would you be in favor of having your petitioner retry?
Your Honor, we are asking, and it's an intermediate step, that the case be remanded to the 11th Circuit to apply the plain error standard to the record of the trial, at Mr. Greer's trial that he had. And then if the court decides that the remedy is a retrial, then certainly that would be what we would be doing.
Do you have any doubt that in this case the government would have preferred to introduce the evidence that you say is lacking here?
Your Honor, there was the old chief stipulation, and when Mr. Greer entered into that stipulation, he did so in accordance with the then binding precedent. He had no ill intent to have entered into that stipulation other than in conformance with the law. And at this point, on appeal, it would be unfair for the government to be able to point to the evidence that says it could have introduced without doing so and having its information then subjected to a defense at a hearing. We are left in this case with no fact finder in the district court on this mens rea element.
So what your approach, though, would put someone who stipulates in a better position than someone who actually goes to trial.
Your Honor, with respect to the scope, it will just depend on a case-by-case. Did the government establish the defendant's guilt at his trial? And it's really just a function of the fact that the uniform precedent has now been overturned by Rahafe because that precedent had turned out to be incorrect.
Thank you.
Justice Breyer?
Good morning. This question may seem naive and simple-minded, but I don't mean it to be. What's the trial record?
Yes, Your Honor. It will depend on what the specific claimed error here. And with respect
okay. That's, in other words, what you look at depends on the nature of the error.
Yes, Your Honor.
Okay. So here we have, well, I understand what the error is. Substantial rights, were they affected? I'm on the appeals court. You have to give me some reason to think they were. Okay. What were they? Now you say, only look at. But why? Why? Why only look at the PSAs and the record? Why? What's the rule? I mean, why? There could have been something that happened before the trial, an error. There could be something happen in the middle of the trial to which it's highly relevant what happened before the trial. There could be something on the list of witnesses. There could be a limitation on what's going to be asked. The limitation having been worked out by counsel or having been worked out with the judge before the jury was impaneled. I mean, the possibilities are endless. So where does this idea come from? You can only look to certain things, at least where we don't have to go beyond saying the record, of which the PSA is part. Indeed, you could go to sentencing 2 minutes after the jury comes in with a guilty verdict. Same day, within the hour. I mean, you know, it all depends. So what's wrong with what I'm saying? That there is no rule. The only rule is the defendant has to show that there's a reasonable likelihood But it did affect my substantial rights. And no appeals court's going to have a big hearing. Put it in the brief. I mean, in other words, I'm totally at sea as to why or how to draw some line. Some case one thing, in some case another is my instinct. Could you explain this to me?
Yes, Your Honor. I'll make 3 points, if I may. The first is, with respect specifically to an insufficient evidence claim, the pertinent record to review on a sufficiency claim was the evidence introduced at the trial. The defendant has the burden of persuasion and may meet that burden by showing that the evidence at his trial did not establish his guilt. And that's because both prongs 3 and prong 4, the outcome of the proceedings is that jury's verdict of guilt. That is what's being reviewed. The PSR in particular was not prepared and is not prepared by rule until after the trial. So that information is not even within the scope of the trial record on a sufficiency claim, Your Honor.
That's why I asked, what's the trial record? You see? Because you could have had it. It depends on what it is. I overstated with an hour, but maybe sometimes an hour. I don't know. Right, the jury's verdict has come in. And the mistake has to do with witness Smith. Witness Smith has already testified. Don't look to the next witness. You see, I fear that we start getting into the rule-making business in this area, what you can look at and what you don't. Poor appellate courts, poor district courts. Do you see what I'm afraid of? A mess, in other words.
Your Honor, just 2 quick responses to that is what's relevant in the trial record itself is already a function of how courts review. If it's an exclusion of evidence, then the court will certainly look at that because that's the claimed error. But in a sufficiency claim, the sufficiency of the evidence at trial is based on the evidence at the trial. And the PSR, by rule, is not even prepared until after the defendant's guilt, or cannot be released without his consent before his guilt. And so my concern is the practical consequences of adopting the 11th Circuit's approach is that that's actually unworkable. Because
Justice Alito? If Mr. Greer had a prior conviction for possession of a firearm by a convicted felon, could an appellate court look at that in determining whether his substantial rights were affected?
No, Your Honor. And the reason is because if the record, even as to that prior conviction, does not address the requisite state of mind at the time of the offense. The defendant must know his status at the time of the instant firearm possession. And without a hearing on that in the district court, the record just does not address that.
Suppose that a defendant was convicted of homicide, served a 20-year sentence, and 3 days after being released from prison was arrested for possession of a firearm by a convicted felon. Would you say the same thing there?
Your Honor, yes. And the reason is it's still, in order for an appellate court to review the errors, it should review whether the government established the defendant's guilt at his trial, because otherwise what will happen is an appellate court will be making a determination of guilt or likely guilt for the first time on appeal, and that process may end up with different results depending on which court is looking at it. By confining the court to what was produced at the trial.
Yeah, I understand your argument. Suppose the defendant was the named plaintiff in a lawsuit challenging the disqualification of convicted felons from voting, or suppose the defendant had written a book about his prison experience, and in the book describing the 10 years he spent in prison, he says, I was convicted of this felony. Could the court look at any of those?
No, Your Honor, and I understand that it looks like that defendant may know his status, but the question still for the fairness, integrity, and reputation of the proceedings, which is an outcome of the outcome of the proceedings is a guilty verdict, is that the nature of the error should be reviewed based on what happened at the defendant's trial.
Well, in all of the examples that I gave, what do you think the effect on the integrity and public reputation of the legal system would be if the court ordered a new trial?
It would preserve the fairness, integrity, and reputation of the proceedings because the court is maintaining its role as a reviewer and not as a potential initial fact finder of a defendant's guilt or likely guilt. And that's particularly true because although these are examples where it may seem like the defendant's guilt has been established, the rule being applied here is being applied to everyone.
Well, what is the basis for your rule? Is it based on the Sixth Amendment? Is it based on the text of Rule 52? Is it based on any decision of this court?
It is based on the standards themselves and the text of 52, the prong 4 standard from the decisions of this court, and it is informed by the Constitution.
How can there be a constitutional? Do you think there's a Sixth Amendment jury trial right on the issue of whether the granting relief would affect the fairness, integrity, and public reputation of the legal system? Do you think that's an issue that it needs to be submitted to a jury?
Your Honor, what has happened in this case is there has been no fact finder in the district court, either the trial judge or the jury, on this mens rea element. And so, yes, there is a Sixth Amendment component. There's also a Fifth Amendment component because this element of the offense was not charged or heard in the district court at any proceeding.
All right, thank you. My time is up.
Justice Sotomayor?
Counsel, I think Justice Scalia would have agreed with you by his dissent in Nieder, but putting that aside, I have two questions that I hope you'll get to in my time. The first is, I don't know that the focus of prong 3 and prong 4 are the same. Prong 3, I think, but clearly is related to the proceeding at issue. Would he have been found guilty? But prong 4 is talking more broadly about the public's perception of the judicial system as qua system. And so I don't know that the answer to your question is the same with respect to prong 3 and prong 4. I understand your argument that whether this proceeding would have been different, yes, under prong 3, and so that you may have shown prejudice. But with respect to prong 4, I think that what the public would be looking at, qua the judge as well, is the entire proceeding. And there I don't see why a judge can't look at the facts of a particular case from beginning to end to determine whether the public would have seen this as an injustice. And given all of the circumstances or potential circumstances, some of which are just like this case that Justice Alito mentioned, your defendant was just released from prison 6 months before he was arrested for this charge, and he had served either 20 months or 36 months. It's impossible to believe that there's any reasonable doubt that he could have put his knowledge in contention. So why am I looking at this the wrong way?
Well, Your Honor, even at prong 4, and I'll refer to the court's decision in Johnson, even in prong 4, the outcome of the proceedings is still a guilty verdict. And in Johnson, the court was able to affirm, based on the overwhelming evidence on the element before the fact finder at the trial. And in the later case of Marcus, for example, the court addressed the fact that that was such an instance where the verdict had not undermined the fairness, integrity, and reputation of proceedings, and that was because the evidence at the trial had...
That is assuming we're looking just at that proceeding to understand it as an outcome of the trial, but the conviction is the issue. I do have a question in your response to the Chief Justice, okay? Certainly, if on prong 4, the record did show some contravention at the sentencing hearing or et cetera, that mental health was at issue, the appellate court could look at that. But I go a step further, assuming that because nobody thought knowledge was at issue, that evidence had never made it into the record. I'm not sure that you could present it. As I see Federal Rule 10, Federal Appellate Procedure Rule 10E2C, it only allows for corrections of errors in the record to bring in new evidence only if it was an error. And the court can take judicial notice of undisputed facts. But if there's something that's not in the record at all, and I'm talking just a trial record, but not there at all, but it's something you didn't put in because you didn't know it would be at issue, do you know of any way for you to get it before the appellate court?
No, Your Honor, and that is precisely the problem here is on appeal, we cannot introduce new evidence. And the record here, because of the uniform precedent before Rahave, the record was not constructed to address the defendant's mental state.
Justice Kagan?
Ms. Gallardo, a couple of things that you've said today have raised a question in my mind, which is, are you arguing that plain error review is limited to the trial record in all instructional error cases? Or are you arguing that that's true only in cases where there's been an intervening change in law of the kind we did in Rahave?
Your Honor, our question presented is specific to intervening cases, but just in accordance with the court's precedents, ordinarily the court will review the errors that occurred at the trial. So even without an intervening case, the relevant record would be the trial.
So you don't think that there's any basis for distinguishing between the two? This really is a broader argument about all errors.
It is, Your Honor, but I do acknowledge that our question presented is focused on the intervening case. Okay,
what I'm more interested in is if it is that broad question, I mean, how to square that with the entire idea of the plain error doctrine. Because, plain error is meant to encourage timely objections, give the court time to correct it, build a factual record, so on and so forth. But on your rule, on the broad rule, the defendant can get a bare record if he just stays silent. And, usually a bare record will mean reversal. So wouldn't that approach give the defendant an incentive not to object? And, of course, that won't be true in cases where there's an intervening change in law. But where there's not, isn't he left in a better place than if he did object? And aren't we creating the wrong incentives?
Your Honor, I think respectfully, because the government does have the burden of establishing guilt at a trial, I think the rule that we're proposing or asking the court to consider still does two things. It requires the government to prove its case at trial, and by asking an appellate court to look at what happened at the trial, or at least not risking what's going beyond what the court has sanctioned before, by having an appellate court in the first instance look at information, evidence that was never introduced at trial, and imagine a hypothetical trial, and affirm the defendant's guilt based on that.
Okay, thank you.
Justice Gorsuch?
Counsel, good morning. I'd like to understand your Sixth Amendment argument just a little bit better. And the government argues that it proves too much because courts of appeals, when conducting a prejudice analysis of trial within the trial court record, would, on your account, usurp the jury's fact-finding function. What do you say to that concern?
Your Honor, what has happened here goes well beyond what happened in Nieder, for example. In Nieder, there was a fact finder on all of the elements of the offense.
Well, I'm really not so concerned about Nieder as the principle that we often conduct, as appellate judges, a prejudice analysis of trial court errors, and we don't think of that as usurping the Sixth Amendment function of the jury because we're dealing with a forfeited error. And it's the forfeiture that cuts the Gordian knot of the Sixth Amendment concern. That's normally how we conceive of it. That's how the government conceives of it. You obviously see it differently, and I just want to understand how.
Yes, Your Honor. And the difference here is that there has never been a fact finder in the district court as to the mens rea element required by this court in Rahave. That is. But
that's due to the forfeiture, the government would say, and that's what allows, again, whether it's in the trial record or out of the trial record, us as appellate judges to conduct a prejudice analysis without infringing the jury's functions.
It is a forfeiture, But even in a plain error review, once an appellate court is no longer looking at what was before the fact finder, that does implicate the defendant's Sixth Amendment rights, which have, even in a plain error context, are not waived. They're forfeited.
So let me try it one more time, and I'll stop there. But why wouldn't the same concerns apply when we're looking at matters within the trial record, when we're assessing a forfeited argument, and we're asking, as we always do, even within the trial record, whether that would have made a difference to a jury?
Yes, Your Honor. When we're looking at the trial record, when we're looking at the evidence before the fact finder, then the court is at least conducting a review of the fact finder and not then risking stepping into the role of a jury or serving as a second jury. It is. I would
have thought a defendant might have argued that is an epistemological impossibility, and we don't know what the jury would have done, and we are usurping the Sixth Amendment function, but we don't think that.
I think I would submit that if the court confines its review to the trial record, then it is at least not going beyond. And it's not going beyond, for example, what happened in Nieder, where here an appellate court is looking at information that was never presented to the fact finder, and any fact finder in the first instance.
Thank you.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Ms. Guaiardo. I want to focus on the old Chief's stipulation. I think your argument has to be as a matter of theory that your client might have been acquitted if proper instructions had been given because he did not know that he had committed those qualifying felonies. That at least has to be the theory. And the government says the old Chief's stipulation is really quite inconsistent with any such theory and prevented the government from introducing evidence about the felonies, which would, as the government says, reinforce the natural inference that the defendant was undoubtedly aware of that criminal record when he possessed the gun. And other courts have pointed out it's not something you're likely to forget to begin with. So your response to that argument?
Yes, Your Honor. First, the old Chief stipulation is entered with counsel at or around right at the beginning of the trial ordinarily. So it's a counseled stipulation that the defendant has the felon status, and in Mr. Greer's case does not address whether he knew his status at the time of the gun possession. And then in terms of the record and the appellate court's approach to this, Mr. Greer, like other pre-Rahafe defendants, entered into that stipulation based on the uniform precedent at the time, and were not, acting with any bad intent as to how the government would have proven its case without the error. But in fact, that's what I would point to is without the error, an appellate court can't just look at what the government says it could have produced without that information then actually being produced to a fact finder and subjected to the adversarial testing by the defendant. Because at that point, then the appellate court is just picturing half of a hypothetical trial.
In your experience, how often are old Chief stipulations entered to in 922G cases of this kind that go to trial?
Before Rahafe, they were, I think, entered into quite frequently. My understanding after Rahafe is that the old Chief stipulation looks different. It usually will include not only the defendant's felon status, but his knowledge at the time. And that's not the type of old Chief stipulation we clearly had.
Thank you.
Justice Barrett?
Good morning, Ms. Guaiardo. I have a question. You've gotten a lot of questions today pointing out the distinction between Step 3 and Step 4 in the plain error analysis. And Justice Alito was asking you questions about, what if the defendant had written a book about his experience as a felon and on and on. In your view, do Steps 3 and 4 do anything distinct? Because then, the government's pointed out, and I think many of the questions you've gotten show that Step 3 maybe has a jury focus, but Step 4 doesn't have anything to do with what the jury would think. It has to do more with what the public would think. Do you see them as having any kind of different function, or essentially under your analysis, we just stop at Step 3 because if it would have led to a different result, then there's no need really to do anything different in Step 4?
Your Honor, I have two responses to that. No, the prongs 3 and 4 do not automatically collapse. But it is true that given the nature of the error, when the nature of the error is the insufficient evidence of the defendant's guilt at his trial, some courts, including some of the this court's earliest cases in Weiborg and Clyott and other circuit appellate courts have said they're in the ordinary case, then if at prong 3 the outcome has been affected, then that case may ordinarily meet prong 4. But the second point I would make is that our question presented is not as much about the standards of prongs 3 and 4 and whether they're met on the merits in an individual case. It's what body of evidence an appellate court reviews to make that determination. And even at prong 4, the outcome of the proceedings is the jury's verdict. And is it fair and further the integrity and reputation of the proceedings for an appellate court to affirm a defendant's conviction even if the evidence at his trial is not sufficient? And that could be the result if this court adopts the appellate process, which allows a court to look at things that were never introduced against.
Okay, so let me just make sure, Ms. Guayardo, that I understand your argument. Essentially, then, under your argument, we could stop at prong 3 because the answer would never be different necessarily under prong 4.
The answer may be, Your Honor. The court, such as in Rosales-Morales, had left open the possibility that, although that's a guideline error case, the court stated that ordinarily such an error would meet prongs 3 and 4. The court could certainly say that here. We're simply asking the court to focus the appellate courts and limit their review to the evidence actually introduced against the defendant at his trial.
Thank you.
Thank you.
A minute to wrap up, Ms. Guayardo.
Uniform precedent led to errors at Mr. Greer's trial. An appellate court should assess these errors by reviewing the trial that actually occurred. This line, a review of the trial, promotes the fairness, integrity, and reputation of the judicial proceedings. For 3 reasons. It maintains the appellate court's role as a reviewer of errors rather than as an initial fact finder of a defendant's guilt or likely guilt. Second, it thus maintains a review of whether the government has proven a defendant's guilt through sufficient evidence at his trial. And third, it provides a clear line to the appellate courts that avoids future litigation over what information not introduced to trial could be relied on to determine the defendant's guilt. Thank you.
Thank you, counsel. Mr. Snyder?
Mr. Chief Justice, and may it please the court, everyone agrees that petitioner must satisfy all 4 requirements of the plain error standard in order to obtain discretionary relief on his forfeited claims. The only question in dispute here is whether the Court of Appeals was required to completely ignore some of the evidence in the record in determining whether petitioner has made those necessary showings. This court has never constrained plain error review in that way, and it should not start here. Plain error doctrine is intensely practical, asking about substantive outcomes and fundamental fairness. The court has always analyzed those questions in light of all the evidence available to it. Indeed, the court has even looked to evidence from outside the record. In Nieder, for example, the court emphasized that on appeal, the defendant hadn't pointed to any new evidence he might introduce if he got a new trial. And in Rosales-Morales, the court looked to a compilation of psychology research in answering how the error at issue there would affect public perceptions of the proceedings. Petitioner has identified no principled reason why a court can consider those sources, but must ignore the undisputed evidence in the record about his own convictions and prison time. Petitioner's rule would also be contrary to this court's admonitions that plain error relief should be rare and reserved for genuine injustices. Under the approach adopted by the vast majority of circuits, courts can consider all the relevant evidence and grant case-by-case relief whenever the error might realistically matter. Petitioner's rule, by contrast, would require nearly automatic reversal for many defendants, like petitioner himself, who do not and cannot plausibly claim that they would have disputed their knowledge of status at an error-free trial, but seek windfall relief based on an artificially constrained view of the evidence. The court should not rework plain error doctrine in that essentially arbitrary and fundamentally unfair way. I welcome the court's question.
Counsel, is the government's position that the reviewing court can always look outside the trial record, or does it depend on the particular circumstances?
Our view is that the court can always look outside the trial record and consider other evidence in the record that is relevant to the error identified.
So does it depend on the nature of what they're looking at? In other words, let's say that what they want, the reviewing court wants to consider evidence of a discussion between 2 other prisoners or whatever, in which the discussion is well, so-and-so knew that it was a felony and why that's what he told me and so on and so forth. Can they just look at that, or does it depend upon the admissible nature of the evidence?
Your Honor, I think at some level it would depend on the admissible nature of the evidence, not in the sense that the specific evidence in the format that the appellate court would be looking at needs necessarily to be admissible. But the question that the court on appeal is trying to answer is whether the result at trial would have been different but for the error, and whether it would be fundamentally unfair to hold the defendant to his forfeiture. And so if it's clear to the appellate court from the evidence before it that an error-free trial would have included that sort of evidence, or that a new trial on remand would include that sort of evidence, such that there's no reasonable probability that correcting the error would have any real-world effect other than requiring a new trial, the Court of Appeals can deny relief in that circumstance.
Well, so you're saying that they can look at not only evidence that may or may not have been submitted at trial, maybe, but also evidence that would not be admissible.
Your Honor, I'm not saying that they can consider evidence that is not admissible. I'm saying that they can consider what evidence would be admissible. I recognize that that's a fine line. The sort of scenario I'm imagining is a scenario where the court is looking to hearsay evidence, but there's no reason to doubt, for example, that the court would be able to present that evidence in an admissible form at trial. It came into the PSR, for example, in a form that didn't comply with the rules of evidence because it was coming in for purposes of sentencing.
Counsel, just to stop you, the court would, for example, have to judge trial tactics, whether a particular lawyer would want to put that type of evidence in?
Your Honor, I think that is a function of the standard that the court is applying. The standard is whether the defendant has shown a reasonable probability of a different outcome at an error-free trial. And so in assessing that, yes, the court might need to assess how counsel would have proceeded, but I don't think that speaks to the scope of the evidence that the court can consider there, or suggests that the court should ignore evidence like the evidence here that's clearly relevant to the error.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, would you spend just a few minutes on a response to the constitutional concern that petitioner's counsel raised?
I'd be happy to, Your Honor. So petitioner's counsel has tried to make this case out as an instance where an appellate court is being asked to find petitioner guilty on one of the elements of the offense. And respectfully, that's really not what's at issue here. There is no dispute that a defendant can waive a constitutional right by failing to assert it in a timely fashion. And there is no dispute that petitioner did so here. He failed to raise these objections at trial. And so the only question is whether an appellate court is going to relieve him from that forfeiture. And there is no reason that an appellate court, in performing that fundamentally judicial function, can't look to evidence in the record that's relevant to it. Doing so doesn't in any way usurp the function of the jury.
So do you think that the analysis, I gather you think you seem to suggest the analysis would be different had this not been in the context of a forfeiture?
Well, Your Honor, I think the prong 4 analysis here is very easy. In Nieder, for example, I think all of the justices recognize that in a case of unpreserved error, it would be appropriate to deny relief based on these sorts of considerations. I think that even in a case of preserved error, Nieder teaches that the relevant question is whether if you had an error-free trial, the result would have been the same. And so we would argue that under that view, you can look at the evidence that would have come in at an error-free trial. So we think we prevail at both steps of that analysis, but I would agree that prong 4 is in some ways the easier way for us to win.
The old chief seems to have limited the ways in which the government can challenge stipulations, or at least craft the whole analysis of stipulations. Do we have to address old chief in order for you to win?
No, I don't think so, Your Honor. I mean, petitioner has not identified a single case in which this court has ever refused to consider evidence in performing harmless error or plain error review because that evidence wasn't in the trial record. And so we think it's enough for you to say here that you could look to the evidence that came in at sentencing and assessing whether the error here should be corrected on plain error review, and you don't need to address Old Chief. We do think that Old Chief is significant, though, in the sense that what petitioner is really trying to do here is ask an appellate court to forgive his forfeiture and allow him to get the benefit of the new law that this court adopted in Rehaif, while at the same time holding the government to the limits imposed by the old pre-Rehaif understanding of Old Chief.
Thank you.
Justice Breyer?
Well, one quick question. It seems to favor you, but you're going to hear a rebuttal. So, I mean, look, there's an error, okay, at the trial. It seems like it's absolutely harmless. It had to do with what the weather was like on a certain day. Was it raining? And it was walking out in the middle of it and would have known, you know? I mean, okay. But actually, there is a defense, you know, and it has to do with that. The defense is it's something that's not in the record. Is there anything to prevent the defendant from telling the Court of Appeals that? I mean,
no, Your Honor,
brief. And if they don't hear about it until your brief, which came later, theirs comes, I mean, they're the appellants, yours comes later, so then they file a reply brief. They don't have to, the Court of Appeals doesn't have to make any finding, does it? I mean, it just has to send it back. Am I right or wrong about that? I wasn't a trial judge, but I was an appeals court judge.
If I'm understanding the question correctly, Your Honor, we are fine with a rule that says that the defendant...
No, I want to know how it works. I mean, I would have thought, trying to remember, that if the appellant, who was the defendant, had some extra evidence that they didn't put in because of the error, they would tell the appeals court that, and indeed describe it. And if they didn't find out about it until late in the appeal, they'd file an extra brief. Am I right about that?
Yes, you're right about that, Your Honor.
Okay. If I'm right about that, then I get to my more difficult question for me. Surely there is some limit about what the Court of Appeals could look to. How would you describe it? I mean, I have a pretty good intuitive idea, I think. You don't want to be unfair. You don't want to go too far. You have to recognize the comparative expertise of appeals courts and district courts. You have to understand the difficulty of getting evidence, I could list some practical facts. What I can't figure out how to do, and this is the advantage the other side has here, I can't figure out how to embody when it goes too far in a form of words.
So two things to that.
Have you thought of any?
I'm sorry, I missed the last part of what you said.
Have you thought of some words as to when it goes too far? You think confining it to, quote, trial records. I don't know what the trial record is exactly, really. But you want to go beyond that. Of course you can go beyond that. You say, fine. When does it go too far? If you were me, what words would you write in the opinion to describe when it goes too far and when it doesn't?
Well, what I would start with is Rule of Appellate Procedure 10, which says that the record on appeal includes all of the papers and exhibits, as well as the transcripts of proceedings in the district court. And so if you're looking for a textual hook, that is
that's your case. But if I go beyond that, like Justice Alito's book. Justice Alito's book wasn't in the record. Is there ever a time when you can go beyond the record? Maybe so. What about the weather report? What about, I mean, you know, things that seem absolutely obvious. What about so I'm not certain I want to say. Maybe we don't answer it. Maybe we just say record, as you say. But I just wondered if you thought about that, if you have a form of words.
So we haven't thought of a specific formulation because, as you say, it's not presented here. The government has agreed in some cases to supplementation of the record when defendants have sought to supplement post-rehaif. I'd point you to the Triggs case in the Seventh Circuit, which is at 963 F. 3rd 710. And you'd need to look to the district court record there, but there is a consented to motion to supplement the record.
Justice Alito?
Suppose there's a case where the defendant would have a plausible claim, maybe a more than plausible claim, that he or she did not recall a felony conviction. Let's say it occurred 20 years ago. The offense was not labeled a felony under state law, but it qualifies under the felon in possession statute. The defendant was sentenced to probation. So there's a potential defense there if the issue had been, if the trial judge had anticipated our decision. In determining whether there was plain error, could the government rely on, let's say, an affidavit by somebody who spoke to the defendant shortly before the defendant was arrested, and the affidavit says the defendant said, well, you know, I know I was convicted of a felony, and I can't have a gun, but I really feel that I must have a gun for self-defense.
So in that sort of circumstance, Your Honor, where I assume that this is from outside of the record.
Yeah, it's outside of the record.
In that circumstance, I think the more the government tried to rely on something like that's truly outside the record and that really puts at issue credibility of that affidavit, I think it's more likely in those circumstances that the defendant is going to be able to make the substantive showing that the plain error standard requires and going to be able to show that there's a reasonable probability that the jury would have agreed with him and disagreed with the government on that piece of evidence. But in a case like this one, where the petitioner has not offered any reason at all to doubt that he had 5 prior convictions and had served 6 years in prison, and indeed has never claimed that he was unaware of his felon status, that in that circumstance, the Court of Appeals, looking to all of the evidence available to it, can properly determine that he hasn't shown that his substantive rights were affected.
Well, no, I understand this is a different case, but back to my hypothetical case. Would it be improper for the appeals court to consider the affidavit? And if so, this is similar to the question I think Justice Breyer was trying to get an answer to. What is the standard that should be applied in that situation? Is it just a question of basic fairness, reliability?
I think that's right, Your Honor. I don't want to rule out the possibility there, and it's beyond this case, but I think the ultimate question there would be the question that the court asks at prong 4 of the plain error analysis, which is one of fundamental fairness.
All right, thank you.
Justice Sotomayor?
So you were about to make to say something, a concession of some sort when you were being questioned, I believe, by one of my colleagues. There does seem to be an unfairness to a defendant in this situation who doesn't know knowledge is at issue and who may not have created a record about knowledge, but he has all sorts of evidence to show mental illness, all of the factors that Justice Alito set forth, mental illness, or he was young, the judge didn't tell him it was a felony, his lawyer didn't. Under state law, it wasn't classified as a felony, but none of that is in the record. You seem to concede he could put that into the appellate record. I just don't see what rule gives him an opportunity to do that, number one. Number two, if there's no explicit rule, are you willing to concede that we should say there is that assumption? And then number three, going back to Justice Breyer's question, is it an equal or unequal opportunity? Do you have a chance to put forth countervailing evidence? And at what point does the appellate court become a trier of fact rather than a reviewer of legal error? Because if you're going to let the government put in all its counter evidence that's not in the record, don't we become triers of fact?
So let me try to take those in the order you gave them. On the first question, Your Honor, as I said, we have agreed to supplementation of the record under Rule 10.
But I don't want something that depends on your agreement. There has to be a legal compulsion to do it. So how do we write it?
So Rule 10 speaks to evidence that was omitted by error. And so you could conceive of supplementation of the record in this case as allowing the introduction of evidence that wasn't put in because of the error reflected in rehaif. I wouldn't want to fully commit to that. And so for that reason, on the second question you asked, yes, the government would be comfortable with you saying that courts of appeals can consider that evidence. And indeed, we think Nieder already does that. At page 15 of the opinion in Nieder, the court went out of its way to note that the defendant there had not pointed to any evidence that he would introduce at a new trial. So we think that's already baked into the court's precedents, and we're not seeking to sort of move back from that. And in terms of whether the government could put in additional evidence, we think that, as I said to Justice Alito, I think that starts, you're going to run into problems with the substance of the plain error standard the further the government goes outside of the record. And so most of these cases that have come up have not involved instances in which the government has looked outside of the record. I know there's at least one case that I believe is pending with this court in which there was in which the Court of Appeals took judicial notice of a state conviction, which might present different considerations. But we think that sort of the core place that this court should make clear is permissible is when there is evidence that's already in the record as described by Rule 10.
Justice Kagan?
Mr. Snyder, if I could continue with your answers to Justice Alito's question. I mean, he posited the government coming in with entirely outside of the record evidence, a new witness of some kind. And of course, in this case, it's about a kind of peripheral issue, but that won't always be the case in instructional error cases. The instructional error might go to the very heart of the case. It might go to something like the defendant's intent. And then, as I understood what you were saying to Justice Alito, you were saying, well, the government could bring in all kinds of new witnesses as to that issue on which there was an instructional error, and that would be okay. It would just be that maybe the defendant would have a better prong 4 claim on the merits. And I guess, I don't exactly understand why the defendant would have a better prong 4 claim on the merits, and maybe more importantly, I don't understand really why that's the question as to how the test would come out in the end, as opposed to trying to put some limits on what the government can do in a case like this.
Well, Your Honor, part of the difficulty here is that this just isn't a problem that has come up. The government has not been attempting to put in that sort of very peripheral evidence in plain error cases. We think it's enough to decide this case to say that where the evidence is already in the trial record, already in the record in the district court, that a court can certainly consider that. And we're comfortable with a rule saying that a defendant can point to additional evidence.
If I just understood you correctly, Mr. Snyder, you basically said that what you said previously to Justice Alito, that you could be fine with that not being a part of our holding. That basically that this case involves only record evidence and would be different from a case where the evidence was outside the record. Is that right?
Yes, that is correct. If I could make one more, I think, related point, there's been a discussion, this discussion has sort of focused on the notion that petitioner didn't have any basis for disputing knowledge of status in the district court proceedings, and he said he had no reason to dispute that at sentencing. With respect, I don't think that that's realistic. I mean, prior to rehaif, knowledge of status wasn't an element of the offense. But a defendant had every reason to dispute his knowledge of status as sentencing, because if he had a genuine argument that he didn't know, that would be powerful evidence going to culpability and therefore relevant to
Justice Gorsuch.
Good morning, counsel. I'd like to just understand how this argument that you propose for Rule 52B interacts with how we'd interpret 52A, which we often look at together. If we were to rule for you in this case, would we have to say that when a court conducts a 52A analysis, a harmless error analysis, it's likewise not constricted to the trial court record and can look at other things in the district court record?
No, Justice Gorsuch. The court could resolve this just on prong 4 of the plain error analysis and say that, of course, in considering questions about fundamental fairness and public perceptions of the judicial proceedings, courts can
put aside prong 4 for a moment. Just at prong 3, if we were to decide it there, would we necessarily have to resolve even there the 52A issue, or is there a way to distinguish the two cases?
I don't see any basis for distinguishing the record that the court would look to at prong 3 from the record that the court would look to in the harmless error analysis. Of course, the standards and the burden are different, and so that might lead to different results. But I think the record would be the same for both purposes.
Do you think we would have a greater Sixth Amendment concern in deciding whether a piece of evidence was harmless in its presentation or absence if it's not even for the jury at all? I mean, typically we say it was harmless error that this wasn't presented or this was presented given the overwhelming weight of evidence the jury had before it. It'd be very different. It might be different, I don't know, if it's outside the trial court record altogether.
So, Your Honor, I think this is part of what animated the disagreement in Nieder, and we read the majority as having adopted a rule that at least by logical implication would say that it's permissible to consider evidence that wasn't presented to the jury in harmless error analysis too. At page 15 of the opinion in Nieder, the court addressed the defendant's argument there that it would be impermissible to affirm based on, quote, overwhelming record evidence of guilt the jury did not actually consider, which is very similar to the argument here, and the court rejected that in Nieder.
So you think they do walk together, at least at prong 3?
Yes, we think they walk together at prong 3, and we think that clearly all of this evidence is permissible at prong 4 as well.
Thank you very much.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Snyder. I just want to follow up on the old chief stipulation and just get your view on the significance of that. Is it your position that the old chief stipulation makes it impossible for plain error to be satisfied?
No, Your Honor. So if a defendant had could make a showing that it was reasonably probable that a properly instructed jury would have concluded that he didn't know of his status, the old chief stipulation by itself wouldn't preclude him from obtaining relief.
And how would that evidence just play that out? How in a case where there was an old chief stipulation, and obviously that's just a lawyer, as the opposing counsel pointed out, but you make a big point of that in your brief, and on page 28 seemed to say a defendant who not only failed to raise an objection but also affirmatively utilized the existing law to foreclose the introduction of evidence that would have powerfully demonstrated his knowledge of his status cannot demand that a later reviewing court overlook his forfeiture while adhering to the earlier evidentiary limitations. That sounded pretty categorical to me.
So forgive me if I'm misinterpreting your question. I'm sort of seeing two different questions. One is what evidence can the Court of Appeals consider, and the second is what conclusion does the Court of Appeals have to draw from that. We think the old chief stipulation is relevant, although we don't think it's necessary, to the question of what evidence the Court of Appeals can consider. Petitioner is essentially asking the Court of Appeals to give him the benefit of new law, notwithstanding his forfeiture, while at the same time giving him the benefit of the old law as sort of put into effect by the old chief stipulation, and we think that that is fundamentally unfair. But once you get past that step and the court is looking to all of the evidence available, we don't think the mere fact of the old chief stipulation would mean that a defendant could never show that he was eligible for plain error relief.
Thank you.
Justice Barrett?
Mr. Snyder, so the Seventh Circuit, in considering this question, drew a line between, trial record evidence or all the evidence in the record evidence as a proxy for what's reliable. So things like the PSR, for example. What would be wrong with that? I mean, that would exclude things like Justice Alito's book. but especially in these cases, the PSR is going to list the felonies. It's going to list the dates of the felonies. It's going to list the length of the sentences. Why does the government want more than that, especially in these cases?
We're not asking for more than that, Your Honor. We think that a rule adopting that line would be sufficient to decide this case. There may be other cases in which you have things that aren't at issue here. So I mentioned the possibility of taking judicial notice of the state court documents reflecting a conviction or something along those lines. To be clear, we don't think that the court needs to address those here, but we don't want to foreclose those in a posture where they haven't been briefed and really aren't necessary to the decision.
So you would be happy with a decision that said, you know, the court of appeals can go outside of just what the jury saw, what was before the jury, and considered other record evidence like, for example, the PSR, and just not say anything about whether it's possible at step 4 in another case, in a non-rehafe error case, for the Court of Appeals to go beyond that?
Yes, we'd be happy with a decision that said that.
And then just to go back to some of Justice Sotomayor's questions, do you agree in that circumstance, if the government could point to the PSR, that the defendant could cast doubt on the reliability of that evidence with things that may go outside of the record, like, for example, you know, mental capacity or other reasons why the defendant may not have known about it, or maybe inaccuracies in the PSR?
Yes, we're fine with a decision that says that as well.
Thank you.
A minute to wrap up, Mr. Snyder.
Thank you. I'd highlight two things in closing. The first is that petitioner's rule is unnecessary for any defendant who has a plausible argument about why a knowledge of status instruction might actually have mattered at his trial. Our rule would allow courts to evaluate all of the available evidence and grant case-specific relief whenever it would be genuinely unfair to hold a defendant to his forfeiture. Petitioner's rule, by contrast, would grant a windfall to defendants like petitioner himself who cannot reasonably claim to have been unaware of their felon status. And the second related point is the petitioner has really provided no reason at all for requiring courts to ignore evidence in the record at the final step of plain error review. Petitioner is asking the courts to grant him discretionary relief from his forfeiture, and he bears the burden of showing that it would be fundamentally unfair not to do so. If he had a plausible argument about why the sentencing evidence was unreliable or didn't tell the whole story, he'd be free to make that argument, but he has no right to insist that courts just pretend like the evidence doesn't exist in deciding whether to give him the discretionary relief he wants. We'd ask the court to affirm.
Thank you, counsel. Rebuttal, Ms. Guayardo.
Thank you, Your Honor. And if I could make 3 points. The scope of the appellate court's review undertaken here went well beyond what happened in Nieder and Johnson. Johnson, of course, being a prong 4 case. And that is because in Nieder and Johnson, materiality was a known element of the offense that the parties had an opportunity to address before the fact finder in the district court. That record there was then not affected by uniform precedent. That's in contrast to what's happened here. Uniform precedent has affected the record of the entirety of the district court proceedings. Because of that uniform precedent, the defendant's knowledge of status, his mental state required to be guilty of this offense, was never addressed in the district court proceedings, including at sentencing. The second point, then, I'd like to turn to is from this court's case in Olano. In Olano, the court recognized that plain error relief is not limited to those for whom the appellate court presumes or finds may be innocent. It's not a guilt or innocence determination on plain error. It is instead about the fairness, integrity, and reputation of the proceedings. And in this instance, Mr. Greer, and this relates to the third point, we are talking here about where an intervening decision has fundamentally changed what's required to be guilty of the offense. And the appellate process undertaken here, it does not ensure the defendant his guilt has been established by the government at his trial. It does not answer that question, and therefore it's unfair for an appellate court to look outside of what was introduced against the defendant at his trial to make some appellate determination in the first instance about whether the defendant may or may likely be guilty. And what it will end up doing is embroiling the courts in many trials the appellate courts in many trials going forward about whether a defendant may be guilty. Thank you.
Thank you, counsel. The case is submitted.
Let's go!
We will hear argument next in case 2444, United States versus Gary. Mr. Ellis.
Mr. Chief Justice, and may it please the court. The Fourth Circuit's automatic vacatur rule for forfeited rehaif plea colloquy errors is flatly inconsistent with this court's repeated recognition that even the most fundamental rights can be forfeited, and that a court of appeals should recognize a forfeited claim only on a case-by-case basis in exceptional circumstances. The court should reverse for two principal reasons. First, rehaif errors are not automatically or even generally prejudicial. Being convicted of a felony is not the sort of life event that one is ordinarily unaware of or forgets. In the minor of cases, as it is here, it will be implausible that a defendant who pleaded guilty to possessing a gun as a felon would have insisted on going to trial if he'd only known that the government would have to prove that he knew he had previously been convicted of such a serious crime. And second, there's no exception from plain error review for claims that were foreclosed by circuit precedent at the time of the district court's proceedings. This court's decisions in Puckett and Johnson rightly recognize that the court lacks authority to create such an atextual exception out of whole cloth, and those holdings equally apply here. Plain error review is not an absolute bar to relief. As demonstrated by the experience of every other court of appeals in the wake of this court's decision in rehaif, courts can and should grant relief under that standard in cases where a rehaif error has truly worked an injustice. The Fourth Circuit's per se rule would thus only serve to undermine the careful balance between judicial efficiency and fairness established by the federal rules and to provide a windfall to defendants like respondents whose convictions were and remain fundamentally fair. The court should reverse the decision below, hold that forfeited rehaif plea colloquy claims are subject to the same case-specific plain error review as any other forfeited claim, and make clear the respondent cannot make that showing. I welcome the court's questions.
Mr. Ellis, under the government's theory, does it matter which element the district court omits during the plea colloquy, or does the omission of an element never constitute structural error?
We don't think the omission of an element ever constitutes structural error, and we don't think that any omission of an element would warrant a per se approach to plain error review. We think the court's decision in Henderson v. Morgan and Boozley are instructive on that point. Now, the nature of the element would inform both the prong 3 analysis as to whether the defendant can show prejudice and the prong 4 analysis, but we don't think it justifies a per se rule.
So if a district court advises the defendant during the plea colloquy that murder is a strict liability offense and it doesn't matter whether he has the intent to kill or not, you think that you don't have a per se rule there in a situation like that would be structural error?
No, Your Honor, we don't think that would be structural error. I think that is pretty analogous, actually, to the facts at issue in Henderson v. Morgan, a case where the defendant, the court didn't inform the defendant that he had to have the intent to kill for a second-degree murder conviction. And even there, the court didn't grant relief without noting that it couldn't be harmless beyond a reasonable doubt. The structural errors are limited class, and they are those errors that really go to the overall structure of the proceeding and not a discrete error within it. And that includes serious errors don't qualify as structural errors. That doesn't mean the defendant can't show prejudice on a case-specific basis, but it does mean that it should be required to do so.
What if it's just not one element, but 2 elements, 3 elements, doesn't matter?
So,
no structural error if, there are 4 elements to the offense and the judge leaves out 3 of them?
So, this court's decision on Dominguez Benitez, footnote 10, suggests that there might be some structural errors in the plea colloquy context. It pointed there to the decision Boykin v. Alabama. That's pretty far afield from what we have here. It's not even just an elements problem. In that case, the defendant pleaded guilty without being asked a single question about the nature, to make sure he understood the nature of the charges or the consequences or the rights he was giving up. We do think, that might arise to a structural error. Something short of that, it's going to be a harder case than the one here. I think the court grappled with the same sort of problem than Nieder, where Justice Scalia made a similar argument in dissent. Well, what the court said there was, we're not going to go take this penny in for pound approach. We're not going to categorize all elements errors as structural errors just because there might be hard cases at the margins. And the last thing I'd say about that is we haven't seen cases that sort of press that line to date. And I think there's good reason for that. As you get more and more egregious errors, it's just not going to matter if you label it structural or not. A defendant's going to be able to make a prejudice showing.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, would you briefly comment on respondents' harmless error review and approach to this case?
So I think you're referring to the respondent's argument that he shouldn't have to satisfy plain error review? Yeah. So that is obviously an issue that he didn't raise below, and it's raising for the first time here. We think the court has discretion to reach it, and we think it's flatly contrary to the court's decision in Johnson. The court in Johnson and Puckett recognized both that the court doesn't have authority to create exceptions to the text of 52B, and the text of 52B doesn't admit of any exception for a feudal exception. In Johnson, there was near universal circuit precedent against the decision at the time when the error was waived, and still the court subjected it to plain error review. The way it accounted for that in Johnson was at the second prong of plain error review. It said that the court's going to analyze the plainness of the error based on the law at the time of appeal. And that means that even in a circumstance like that, where you forfeited a claim that was barred by circuit precedent, you can still get relief under plain error review. You just have to satisfy the third and fourth prongs. We think that's the balance, and the court should reaffirm that approach here.
Can you think of, I may have missed this in your discussion with the Chief Justice, but can you think of any error that would require automatic vacature under plain error?
Under plain error? No, Your Honor, the court hasn't identified one, and what it has said repeatedly in Young and Puckett is that a per se approach to plain error is flawed. The rules of plain error are intended to set up a system where you are encouraged and incentivized to raise your claims in a timely manner, and then provide a safety valve for courts of appeals to exercise their discretion to recognize a forfeited claim when there has been a showing of prejudice and when it would undermine the fairness and integrity of judicial proceedings not to do so. But we don't think there's a per se rule for any type of error.
Thank you.
Justice Breyer?
No, thank you very much. I have no question.
Justice Alito?
If we were to rule for Mr. Gary in this case, do you have an estimate of the number of cases pending in the courts of appeals or before this court that would be affected?
So we noted in our brief there are 80 cases being held, about 82 cases being held out of the Fourth Circuit, the only circuit to not apply the normal plain error standards here that would be affected. Obviously, the court's decision would have broader effect across the board, and we don't have I can't give you an estimate of that number of cases. What I can point out is that the 922G prosecutions are among the most common in the federal system. In 2019, we cited a study on page 42 of our opening brief. They accounted for nearly 10%, or actually I think just over 10% of all federal prosecutions. That was 7,500 cases. And so, the Gary's rule here would require automatic vacature of all those claims in which they're asserted on direct appeal. I'd also point out that, whatever the burden is as a quantitative matter, qualitatively, it just doesn't make any sense. The other circuits and the ordinary principles of plain error review allow defendants who are actually harmed by a rehaif error to get relief under plain error review. And so really the Fourth Circuit's per se rule has the effect of just catching those cases where a defendant can't make a plausible claim like this one, that it would have made a difference in the proceeding.
Well, the respondent suggests that automatic vacature in cases like this won't impose a significant burden on the judiciary because most defendants will readily plead guilty again. Is that true?
It's hard to predict what defendants will do. I guess the fact that they're asserting it on appeal suggests that they're not intending to do the exact same thing they did the first time, even if had the error been raised, they would have. I think that as far as concerns about a counsel raising a litany of futile objections, I'd say two things. The first is that Johnson already dealt with that. As I noted, that very argument was made in Johnson. The court agreed with that was a legitimate concern, but held that the right approach was to make plain error, the second prong of plain error, turn on the law at the time of appeal. That means that you're not foreclosed entirely when there's a change of law, but you still have to make a prejudice showing. And in the wake of that, we haven't seen a litany of futile objections being raised. I think that's good reason. Defense counsel have all the incentive to focus on claims that might actually make a difference. And they can know that even for forfeited claims where there's a change of law, their client can get relief if it made under plain error review, if it really made a difference and worked in justice.
Thank you. Justice Sotomayor?
Counsel, this is a very different kind of case than our other plain error cases, because in our other cases, the defendant had a reason for putting forth a defense. So whether it was neither, the defendant knew that someone had to find materiality. It was the same thing in Johnson. But this is the kind of case where no defendant knew that there could be an actual defense at all. So why wouldn't we find that a structural error? You're admitting the requirement of an offense at all, and even if we found it to be structural error under prong 3, why wouldn't you win under prong 4? Because assuming that a court can look at the entire record under prong 4, here the defendant admitted to the probation officer and to the court, I believe, that he knew he was a felon. So don't you win either way?
We do. We agree with that. We win either way. I think Johnson and Cotton make crystal clear that even if you decide this is a kind of error is a structural error, that it still has to satisfy prong 4. And I agree entirely with the premise of your question, Your Honor, that the defendant here would lose on prong 4. That said, I don't think it is right to call this a structural error. You alluded to the fact that the respondent's argument that he wouldn't have an opportunity or incentive to challenge the evidence here as to his knowledge. I don't think that's accurate. As a general matter, the evidence we're relying on here is from the PSR and sentencing, his own statements, as you point out. Defendants have every incentive.
Excuse me, counsel, do you have the same answer to the questions posed earlier about the defendant who really didn't know or have an opportunity to create a record? Do you agree that we should look at those cases, even in a guilty plea, as different than in the normal situation, that a defendant should be able to proffer evidence before the appellate court?
So we haven't gotten into the record questions here. I would say a couple things about that. First, we know, at least with regard to the record before the district court, that's entirely open on.
No, I'm not asking you that, because it never gets back to the district court unless the appellate court says that there was an error that sends the case back. I'm asking the question as if the defendant didn't know and didn't put into the record a plausible defense. Do you agree with your colleague in Greer that that defendant could proffer that in the appellate court?
Yes, Your Honor. We have no objection to a defendant offering that up, proffering that in the first instance to a court of appeals in that instance.
Thank you, counsel.
Justice Kagan?
Mr. Ellis, when you were answering the Chief Justice's hypotheticals earlier, You said that structural errors really all go to the overall structure of the proceeding, and that's why none of the hypotheticals he gave you were in fact instances of structural error. But I had thought that there was a different category of structural error where what we were looking at was some interest that was unrelated to whether there was an erroneous conviction, and in particular, a category where we were concerned with autonomy interests, with the ability of a defendant to make his own choices. And in some of those hypotheticals that the Chief Justice was giving you, I would have thought that there was no such ability to make your own choices, that you have so little information in cases like that, that the autonomy interest is raised to a very high level. So I'm curious as to your response to that.
Sure, Your Honor. So I agree with you that the court in Weaver in particular identified one reason why an error might be a structural one is that it protects an error different than the conviction and specifically flagged autonomy. I'd say first that what Weaver went on to say is that sort of error is still not the kind that should remove or leave a defendant of his requirement to show prejudice, and certainly wouldn't go to the fourth prong. Now, as to whether this kind of error is an autonomy, protected autonomy interest, I think not. I think where the court's found autonomy-based structural errors have been pretty narrow circumstances. So think about McCoy, where the court held that a defendant's autonomy interest was violated, where their counsel conceded guilt over their objection. But in McCoy, the court distinguished that instance from where counsel conceded guilt without an objection.
Well, go back, Mr. Ellis, to the Chief Justice's hypotheticals, or maybe to a couple of different ones. Suppose a defendant pleaded guilty without being informed of any of the elements of the offense. He didn't really even know what crime he was pleading to. Would that be structural error because it interfered with his autonomy interest?
So our view is no, that those sort of autonomy interests, as I was saying with McCoy, are really ones where either the court or the counsel has taken interest over the express objection of a defendant.
Well, how would he even know what to object to if he didn't know anything about what the crime was? I mean, how can a defendant make the choice to plead guilty if he doesn't know what he's pleading to? I would have thought that that's a pretty non-autonomous decision-making.
I'm not disputing the fact that there is some autonomy here when you're not being made a completely knowing choice. The problem with taking that sort of a view of a structural error is that it would suggest that sort of any error in the plea colloquy context and informing of a defendant of his knowledge would risk being a structural error. Either way, I think, Your Honor, what I was saying before, I think what Weaver says is that even in that case, you're going to need to show prejudice, and we know from Johnson and Cotton that you're going to need to show the fourth prong. So I don't think you have to definitively answer that question here. I also think even if you think there are some plea colloquy errors, as I noted to the Chief Justice, that would be structural, be it for autonomy reasons or others, we're not getting close to that here, and we don't think it's really ever going to matter to.
Justice Gorsuch?
You have no questions at this time.
Justice Kavanaugh?
Additional questions?
Justice Barrett?
None for me either.
A minute to wrap up, Mr. Ellis?
Thank you, Mr. Chief Justice. So as I was just discussing with Justice Kagan, I think we acknowledge there are hard questions here in this case about precisely where to draw the line between discrete plea colloquy errors, like the one here, and a more fundamental breakdown in the process where relief should be available under even plain error review. But wherever one might draw that line, this case falls far short of it. When respondent possessed the weapons at issue here, he'd been convicted of 7 different crimes, punishable by more than a year in prison. He'd spent multiple years in prison. He'd been released months before. He knew that he was not supposed to possess a gun. And in that respect, the respondent's circumstances are not atypical of 922G1 defendants across the country. Every other court of appeals has been able to apply the ordinary principles of plain error review to distinguish between cases like this one, where relief would do nothing but award a windfall to a defendant whose conviction is fundamentally fair, and those rare circumstances where rehaif error has worked an injustice. All we're asking is the court reaffirm that well-settled approach.
Thank you, counsel. Mr. Fisher?
Thank you, Mr. Chief Justice, and may it please the court. The due process error here requires automatic reversal for 2 reasons. First, because the error is structural. A core aspect of the autonomy every defendant must be afforded is the ability to decide whether to contest the government's allegations, or instead to relinquish one's physical liberty without trial and submit to a term of imprisonment. Failing to advise a defendant of the complete charge against him necessarily deprives him of the ability to make that grave choice knowingly and intelligently. Indeed, it would trample the framers' vision of free will to enforce a guilty plea where the only facts the defendant admitted do not even constitute a crime, and where, having now been advised of the true nature of the charge, the defendant wants to contest it. Second, the plain error doctrine does not stand in the way of remedying the fundamental constitutional defect here. For starters, the plain error doctrine should not even apply. But even if Olano's test does apply, the result would be the same. Structural errors necessarily satisfy Olano's third prong as a matter of plain text analysis. And, in the words of the fourth prong, it would seriously affect the fairness, integrity, and public reputation of judicial proceedings to allow a guilty plea to stand without fair notice of the charge. And that is especially so where the only reason for withholding relief would be that the defendant failed to make a pointless, totally formalistic objection. That leaves the government's complaint about the practical consequences of having an automatic vacatur rule here. They would be slight. Our rule would do nothing more than return an average of one Section 922 case to each district judge, as the government's own statistics demonstrate. That seems a small price to pay for honoring what this court has long called the first and most universally recognized rule of due process, fair notice of the alleged conduct for which the government seeks to put one of its citizens behind bars. I welcome the court's questions.
Mr. Fisher, I want to talk just a moment about your unanimous the proposed futility exception. What does it take to satisfy that? Unanimous view of the circuits, but only 3 circuits?
Well, Mr. Chief Justice, obviously all you would need to say in this case is the unanimous view of the circuits.
Mr. Fisher, you understand that, I'm not talking about this case, but a general rule.
Fair enough. We're making alternative suggestions to the court. I think the first suggestion is that the court could say plain error does not apply when the unanimous view of the circuits was against the defendant.
So
that is a situation.
2 circuits is unanimous. I mean, is that enough?
Oh, I'm sorry, forgive me. What I mean is every single court with criminal jurisdiction, because that is the situation where it is true futility. There's no circuit split to put the defendant on notice, that the judge on notice that the issue is arguable, and there's no possibility that any other court would adopt the alternative view. And so here you have the truly unique situation that the court has never faced before of true futility. And my alternative submission, Mr. Chief Justice, is that even if you don't think that the plain error doctrine should be set aside here, at the very least, the futility of the objection should be considered as part of the prong 4 analysis. As the conversation this morning in the first case demonstrated, and I think the government's position in our case also demonstrates, that is a broad prong that looks at fundamental fairness and the reputation of proceedings. And so at the very least, we think it would be unfair and would bring disrepute on the judiciary to deny relief in a situation where the defendant had no reason to object, and in fact, it would have been utterly pointless and formalistic to do so.
The cases where we've held that it's not structural error, I think if you put them side by side with yours, it's hard to say that yours is necessarily stronger. The judicial improper participation in the negotiations, the government's actual breach of a plea agreement, if those aren't structural, why is the error in this case?
The thing that sets this case apart, Mr. Chief Justice, well, actually, there are 2 things. The first is what Justice Kagan mentioned, which is the autonomy interest at stake. The court has said that where the defendant is deprived of a choice to make the fundamental decisions about his own defense, that is a different sort of error. And that is the essence of what you have here, which is a defendant who is unable to even decide whether to challenge the government's case in a knowing and intelligent manner. And that leads to the second reason that this is set apart, which is the first and most elemental aspect of due process is fair notice of the charge. And when that is deprived, then everything else that follows cannot be trusted.
Thank you, counsel. Justice Thomas?
I have no questions, Mr. Chief Justice.
Justice Breyer?
What is the difficulty of making, you made all these arguments, fine. So the lawyer for the defendant says to the appeals court or the district judge, we wouldn't have pled guilty. Now you'd have to make it plausible, reasonable, or you wouldn't have, and then that's the end of it. You win. I mean, why call it a structural error? Why not just say the plain error? Show that it was likely that it would have made a difference. End of case. But in a case where there's an element, wasn't known about, et cetera, But It's obvious it wouldn't have made any difference whatsoever. You lose. I mean, why is that a tough system to work?
I think for two reasons, Justice Breyer. The first relates to the answer I gave to the Chief Justice, which is that when you have a violation of the defendant's own autonomy to decide whether to challenge the government's case and submit to a conviction without any trial whatsoever, the bare minimum when you have a guilty plea is that the defendant understand the charge. And that may sound like a formalistic rule, but remember, guilty pleas are themselves an innovation the framers were not even aware of. And so when you're going to introduce something, a conviction without trial, the defendant should at least have fair notice. And so that's the primary. And the second reason is that you simply cannot trust whatever record may have been constructed at the guilty plea colloquy where the defendant has no reason to know that the missing element has any salience at all. And then when you get to the sentence proceeding, the defendant has the opposite incentive. The government said earlier this morning that the defendant would have an incentive to challenge a missing mens rea element at sentencing. But as we cite on page 33 of our red brief, courts have held exactly the opposite, which is that if the defendants at sentencing, having pleaded guilty to what they think is a strict liability offense, turn around and say, well, I didn't know what I did was wrong, judges then hold that against the defendant and deny acceptance of responsibility and give them bigger sentences. So it's just not a record that you can trust on appeal to do any sort of plain error.
Let him present in the briefs. I mean, he says, look, judges in the appeals court, hey, I didn't know that there was this element, obviously. If I had known, I wouldn't have pled guilty. And then you put in a general description of what makes that plausible, reasonable to think in the circumstance. You don't have to go into some big record. Just have to explain it and back it up.
Well, Justice Breyer, two things. One is I think I've made an argument that you shouldn't have to do that because the Fourth Circuit correctly held that the error is structural and that prong 4 is satisfied in this situation. But if you did have to do that,
why shouldn't you have to do it?
The reason why you shouldn't have to do that are, number one, because it's structural error for the reasons I've said, and that satisfies prong 3, because an error that affects substantial rights is necessarily structural. Secondly, prong 4 is satisfied because the autonomy violation and the fundamental fairness violation themselves satisfy prong 4, and even if they didn't, the futility of the exception should, the futility of an objection should be taken into account, and that would show that it would be fundamentally unfair to deny relief. But Justice Breyer, I want to add one last thing, which is we do argue in this case that Mr. Gary would not have pleaded guilty had he known of the element, and we give the reasons why he would have a defense to the mens rea element in rehafe. It's just that is not an issue in front of this court. If we had to make that argument at remand, we would, and we do have an argument that's laid out at the very tail end of our red brief, but we just don't think that's in front of the court.
Justice Alito?
Mr. Fisher, would your autonomy argument mean that every misstatement and every material omission made by a district judge at the Rule 11 proceeding is structural error?
No, Justice Alito. We focus just where the court itself focused on in Boozley and Dominguez Benitez on errors that omit the elements, and so the defendant does not have an understanding of the nature of the charge. And the court has distinguished in both those cases other sorts of errors that go to things like the strength of the government's case or the consequences of a guilty plea or the like.
Well, why wouldn't the autonomy argument apply to any misstatement or omission? That at the Rule 11 proceeding, the judge explains to the defendant the rights that the defendant is giving up and what the government would have to prove if the case went to trial, and the defendant presumably makes a decision about whether to go to trial or plead guilty based on that understanding of what is at stake. And so if the judge misdescribes what is at stake, it seems to me the same autonomy interest is implicated. No? What's wrong with that?
The difference, Justice Alito, is that the autonomy interest here, and the only autonomy interest I think fairly recognized in the court's cases, is understanding the nature of the charge and understanding what you are agreeing that the wrongful conduct you are agreeing that you committed. If you just isolate the element here, Justice Alito, maybe put it this way. which is the defendant has an autonomy interest in whether to admit guilt and subject himself to imprisonment. And then Mr. Greer is here today telling the court, I want to challenge the mens rea element in rehafe. And so the issue in front of the court is whether he gets to make that choice or whether the court makes it for him without him ever being able to make it for himself. And that's a different sort of a choice and a different sort of autonomy violation than technical violations of Rule 11 like you dealt with in Dominguez.
On the issue of futility, if I understand the chronology, at the time when your client pled guilty, Judge Gorsuch's separate opinion in the 10th Circuit on this issue had been issued, in fact, had been on the books for a number of years, and Judge Gorsuch had become Justice Gorsuch. So why was it futile to raise the issue at that time in the district court? Had that been done, we might be talking about Gary cases as opposed to Raif cases.
Well, I think that's the best argument for why the defendant should have raised the objection, but we don't think you can distinguish a situation where there's a single dissent out there from many other situations like where justices of this court have said, I think we should reconsider this precedent or the like. If you're going to hold defendants to require them to object in all of those circumstances, the defenders tell you in the amicus brief and the judges themselves, district judges tell you themselves in their brief, what you're going to be requiring is an omnibus motion at the beginning of every criminal case and objections throughout that are all based on perhaps single judge opinions or single justice dissents that are just going to clog up the machinery of criminal justice. And remember, Rule 2 tells you that you should construe the rules and apply them to seek efficiency, fairness, and simplicity. And the government's position here would give you the opposite.
All right, thank you. Thank you. My time is up.
Justice Sotomayor?
Mr. Fisher, even assuming that this was structural error under prong 3, for the reasons that you stated, or just narrowly because there was no reason for him to know that anyone would have to find this element, and so no reason to proffer to consider this defense at all, don't you still have to meet prong 4? And I don't want you to argue Mr. Greer's case, but assuming that on prong 4, all evidence in the record could be looked at, tell me what defenses are plausible that your client could raise. You mentioned they may have been in your red brief. I just don't remember seeing what they were.
Three things, Justice Sotomayor. First, I agree that we have to satisfy prong 4 if the plain error doctrine applies. And so we have an argument that it doesn't apply, but if it does apply, we have to satisfy prong 4. And then the argument that I'm making to the court here...
No, those are not the arguments I'm looking for. I'm looking for a factual defense to knowledge. Here is a man who was convicted 7 times, multiple separate jail terms, vastly exceeding 1 year. And I think he had been let out of his last conviction months before he was arrested on this charge. So what would have made it, what factual defenses to knowledge would he have plausibly had?
So I'm going to answer your question, Justice Sotomayor, but if you forgive me one quick thing I want to make sure I reserve, which is we do not think this issue is in front of the court. Our argument is that he automatically satisfies prong 4 because of the nature of the error and the futility. But what our argument would be on the facts on remand is that even though he has 7 convictions, none of them were convictions where he served more than 1 year of imprisonment following that conviction. And so the only conviction the government really put in front of the Fourth Circuit is a 2014 burglary conviction. There he served more than a year of pretrial detention, but he was let out on a suspended sentence after the guilty plea. And so he reasonably might have thought that pretrial detention has no relationship, as the court knows, to what the ultimate sentence could be.
How about his admission that he knew he was a felon and that's why he was hiding?
So that was not his admission, Justice Sotomayor. What his admission was, and I'm going to quote here, was that he was aware he was not supposed to have a weapon. He did not say anything about his felon status. And remember, at the outset of this case, he was charged under a state law that prohibited carrying guns without certain, job titles like a policeman or a firefighter or the like, or a fisherman. And so that alone would have told him he couldn't carry a gun for reasons having nothing to do with any felon status.
Thank you, counsel.
Justice Kagan?
Mr. Fisher, like Justice Alito, I'm also trying to get a handle on what you think is autonomy infringing and why. So if we could think about the error in Bowsley, there the court advises the defendant that using a firearm in connection with a drug crime requires only gun possession, but that's not right. In fact, it requires active employment of the firearm. Is that structural?
I think probably, Justice Sotomayor, Justice Kagan, for the same reasons I've described. It's obviously a little bit different because I think that would be thought of as a misdescription of an element and not a total omission. But remember, I think it's telling that the government itself was unwilling to offer you or the Chief Justice any limiting principle. And I think that's the problem, is that we're offering the court a rule that says it is structural error because it violates the autonomy if the defendant does not have true notice of the charge against him.
So misdescription or omission is not your dividing line. So, for example, if the court had told your client that a felon was someone convicted of a crime that carries a sentence of 6 months, that would be just as autonomy infringing. Is that right?
I do not think it would be quite as autonomy infringing, Justice Kagan. I think you could draw that line, but you wouldn't necessarily have to. I think you have to draw a line somewhere. And all we're asking the court to do here is say at least where an element is omitted, then you cannot fairly say that the defendant made a free and voluntary choice to plead guilty.
Right, but when you move back from that, I could imagine cases where an element being omitted is of considerably less importance to anybody's decision to plead as another case where there's been a misdescription of an element.
Again, I will concede that I think that you could put those two cases together, and where you think about laying down a principle in the long run, I think those cases may go together. But just remember, this swings the other direction too, and the government is here saying even if 2 elements are omitted, even if 3 elements are omitted, that's not structural error. Somewhere it has to be structural error.
And
it just seems...
I'm sorry.
Go ahead.
Is your view that this has nothing to do with the question of prejudice? I mean, imagine a case where we think, in light of the nature of the omission or in light of the nature of the misdescription, I mean, every defendant in his right mind would still have pleaded guilty. In that case, we're just not allowed to say that?
That is my argument today, Justice Kagan, and because that is the nature of the error. I mean, I think what you just said is very much what the court said in the Ferretta line of cases, which is no matter how ridiculous it was for the defendant to represent himself or no matter how guilty he may have been, if we violated that right as a court system, the defendant gets automatic relief. And McCoy holds the same thing. And so we just ask the court to recognize that this is the molten core of due process, which is understanding what you are charged with before you submit yourself to prison without a trial. And in that situation, even if it appears formalistic on the surface, it is such a deeply fundamental right, not just on an autonomy level, but fundamental fairness, the third prong of structural error, that you should give automatic relief.
Thank you, Mr. Fisher.
Justice Gorsuch?
Mr. Fisher, I'm still trying to get my hands around your futility argument. The contemporaneous objection rule is heavily embedded in tradition and also in the federal rules. And Rule 51B speaks expressly to the question, and it says that there's no need for an objection if a party does not have an opportunity to object. That's the test. It's not some sense of how many circuits have ruled against it or whether it's likely to lose or how likely it is to lose in front of the district court or in the Court of Appeals. It's an opportunity. And how do you reconcile your argument with that language in Rule 51?
Justice Gorsuch, the way that we construe the text is to apply the canon that where the court incorporates a term of art with prior accumulated legal meaning, that term carries the old soil with it.
Yeah, I just haven't seen any of that from your brief. You mentioned a Second Circuit opinion, but there's nothing from this court that's ever construed an opportunity to object to mean a likelihood of success on that objection.
No, but what the court has done is had decades of cases leading up to 1944 where the rules were codified in this respect that held that where there's an intervening decision that the defendant would have had no reason to see coming, that plain error does not apply. And so
an intervening decision, but here again, there was plenty of notice that this was an available argument out there. It may not be one that the 11th Circuit was likely to have adopted, but
again,
why wasn't, you know, even if we're going to play the sufficient notice game rather than the opportunity game, why wasn't there sufficient notice?
I don't deny there was sufficient notice, but that was never the test the court applied. The case I would most readily direct you to is the Hormel decision.
So hold on. So you agree that there was sufficient notice now?
No, I think obviously your opinion was on the books, and so there was notice of that. I was talking earlier about no notice of the true charge against him because of what the district judge said. The defendant had no.
So there was notice, and he did have an opportunity.
There was no notice of the mens rea element truly being part of the charge.
There's notice that it was an available argument.
You might say that, but again,
okay, and there was nothing that the district court didn't prevent him. There was no restriction of his opportunity. You'd agree with that too?
I can accept that, Justice Gorsuch, but if you let me just point you to one case, which is right before Rule 52 was codified, the Hormel decision, which itself is cited in Olano. The court said...
Yeah, that's Rule 52. I was asking about Rule 51, but my time's expired. Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and welcome, Mr. Fisher. Just to zero in on this particular case and this precise issue in this case, I think you're saying that it's unfair to defendants to have their conviction by trial or plea when the government wasn't required to prove that the defendant knew he was a convicted felon. And the Fifth Circuit said, well, convicted felons typically know they're convicted felons. Judge Wilkinson said felony status is simply not the kind of thing that one forgets. And so from that premise, it seems odd to throw out all the convictions if you accept that premise. So do you accept the premise that convicted felons typically know they're convicted felons?
I think that may be true, Justice Kavanaugh, but one thing is you said pleas and trials. We're focused here just on the plea situation in this case, of course.
Right.
And the question should not be whether defendants are typically aware of the element or the element is typically satisfied. The question should be whether the defendant, when he pleads guilty, understood that was part of the charge and therefore was given an opportunity to exercise his own free will in deciding whether to challenge that element. I mean, obviously in Rahafe, 7 justices of this court thought that the element was quite important, and in fact it separated wrongful from innocent conduct. And so another way to put our submission is that the defendant should at least have the opportunity to decide for himself whether to agree to wrongful conduct and submit to term in prison, even if it's unlikely he would satisfy that. I mean, you could take a case, Justice Kavanaugh, where there's a videotape of the crime, or the defendant later wrote a book about the crime, as Justice Alito was positing this morning, or any number of other things. And we simply cannot allow a system where the defendant is never given an opportunity either to understand the charge and agree to it or to challenge the government's allegations at trial. One of those two things must take place.
Thank you, Mr. Fisher.
Justice Barrett?
Good morning, Mr. Fisher. So should the defendant have to represent to the Court of Appeals that he wouldn't have entered the plea had he known, say, about Rahafe?
I think, Justice Barrett, there's two ways I can understand that question. The answer is no if you're asking, do we have to satisfy the Dominguez test? But I think the answer is yes if you're saying, if you're just saying, should the defendant represent that he wants to withdraw his guilty plea and challenge the government's case? I mean, that's the reason why Mr. Gary is here. There were some questions earlier about statistics, and we've done our best to figure that out on our own end. And it's only, I think, fewer than 10% of the defendants who are on direct review after Rahafe that have made a claim like Mr. Gary's. So it's not like every defendant is making this kind of a claim, and there's no windfall to be gained by making it. The defendants may end up being convicted and getting a longer sentence. Rather, what the defendants like Mr. Gary have decided is that they would like to challenge the government's allegation, and they would like to put on a defense on that element. So that's why they're bringing these appeals.
So do you think that's kind of a natural weed-out mechanism for the point that Judge Wilkinson was making, that, felon status is not the kind of thing that you were going to forget? So the likelihood that they would succeed if indeed they won on appeal and went back and put the government to its proof is itself a deterrent against a flood of cases?
I think so. I think that that's one thing that actually does naturally serve that interest, and if you might want to call it a practical interest in that respect. And remember, these are not decisions that defendants like Mr. Gary make lightly, because once you vacate the guilty plea, the case starts over, and you just go back to square one where you were before, and the government could seek a longer sentence. The government could say he no longer deserves acceptance of responsibility if he's convicted, et cetera.
Thank you, Mr. Fisher.
A minute to wrap up, Mr. Fisher.
Thank you. I think because we've become so accustomed to our system of guilty pleas that I understand the temptation that the court may have to think of this case as involving a request for relief based on a violation of something of a formalistic requirement of criminal procedure. But in fact, this case involves the most fundamental of principles and the most sensitive of practices: a conviction without a trial. Indeed, because of the stakes involved for individuals and the fear of government abuse, as the court knows, the concept of a guilty plea itself was largely unknown to the framers. So we're obviously not asking the court to second-guess the modern development of the guilty plea system, but what we are saying is that an indispensable requirement of a conviction obtained in this manner is fair notice of the true charge, and especially of any element like the mens rea element here that separates wrongful conduct from innocent conduct. So a defendant can at least make an intelligent decision whether to surrender his liberty without even putting the government to its proof. However hazy that principle may appear in the mire of procedural debates about prong 3 and prong 4, et cetera, that we've had today, no constitution designed to secure freedom can function without honoring that fair notice concept. So we ask the court to affirm the Fourth Circuit's automatic vacatur rule. If, however, the court thinks that the defendant needs to show some sort of prejudice, then we'd ask the court to remand to the Fourth Circuit so we can make those arguments in the first instance to the Court of Appeals. With that, we'll submit the case.
Thank you, counsel. Rebuttal, Mr. Ellis.
Thank you, Mr. Chief Justice. Just a few points. First, I think what the respondent's time at the podium this morning makes clear is that he's either offering a highly gerrymandered rule in this case or one that would affect the sea change in both plain error and structural error. As to the gerrymandered nature of futility, he argues that there should be an exception only where the circuit precedent was universal. But if what we're worried about is the district court being able to credit an objection, then all it takes is contrary circuit in that defendant's, contrary precedent in that defendant's circuit. And if we're worried about letting the court or the parties do something to aid in appellate review, like build a factual record or enter a contingent guilty plea, that can happen just as often as it can where there's universal circuit precedent as when there's near universal circuit precedent or anything less. On structural error, it's not clear, as Justice Kagan pointed out, why a mens rea element like this one would be more important to a defendant than the right at issue in Vaughn, which was the right to counsel at trial, or the error in Dominguez Benitez, which was informing the defendant that he couldn't withdraw his plea if the court didn't agree with the government's recommendation for a safety valve, which made the difference between a mandatory minimum of 10 years or only 70 months, could be only 70 months in prison. Even the gerrymandered nature, though, of the rule that he offered doesn't work. On futility, the futility exception is flatly contrary with Johnson. I think it's worth pointing out in that case, the error that was forfeited was one that the court in Gowden had to overrule its own precedent in order to recognize. So it's not clear why that was any more futile in that case than it was here. And as to the structural error, the respondent's argument that any element left out is structural and not susceptible to prejudice analysis, it cannot be squared with this court's decision in Henderson or in Boosley. And so we ask the court to reject that on those grounds as well. Finally, the respondent's counsel ended with a plea that even if the court reverses the Fourth Circuit and says that an automatic rule isn't appropriate, it should remand for the Fourth Circuit to have another crack at it. We'd urge the court not to take that approach. The Fourth Circuit did have a chance to pass on prong 3 and prong 4. It did. It just badly erred. So just as this court did in Cotton, just as it did in Rosales-Morales, we'd urge the court to reach those prongs, to resolve it, and provide guidance to the Fourth Circuit on how it should apply. We'd ask the court to reverse.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.